Okay, we have both counsel with us. Thank you. Attorney Poole, it's my understanding you represent the appellant. Did you wish to reserve time for rebuttal?
Yes, 3 minutes, Your Honor.
3 minutes. Okay, I have made the notation and you may begin.
Good morning. May it please the court. I'm Beverly Poole, representing Mariner Travel International, which does business as the Moorings. The sole question before this court in this case is whether an agreement to arbitrate exists where the plaintiff in the case is not a signatory to the booking terms and conditions which contain the arbitration provision. On the undisputed facts that were developed during limited discovery, the answer to that question is yes. And it's important to note that the material facts really are undisputed, despite the plaintiff's denial that he granted authority to the lead charterer or even knew anything about the contract. That's a legally irrelevant fact under uniform case law. Nor does it matter that the lead charterer said that he thought he was contracting just based on himself. This court just last year in UATP management says that a parent agency is conferred based upon the principal's actions or statement. Continuing the quotation, the inquiry properly focuses on the actions or appearances created by the principal, not the agent. Here, in this case, we have both actions and statements by the principal, which is the plaintiff, or who we say is the principal, the plaintiff, Joshua Paybara. Most importantly, and I think this is really critical to the case, in his answer to request for admissions, which is at appendix page 216, he admitted that he and his wife provided their personal information to Mr. Walker, the lead charter, for use in booking the charter. That's why he gave them personal information, because they authorized him to book the charter.
And of course, once your client got that information, it reached out to him to say, would you please sign these conditions in terms of passage, correct?
No, there was no requirement that every passenger sign them. The way that the contract—
But your client gave notice to him that he would be bound by these terms and conditions, correct?
In the terms and conditions, it says that.
They provided, did your client provide that information to anyone other than the individual who booked the charter?
Not directly,
okay.
But the lead charterer provided the information more than once.
The lead charterer provided the information to your client that the passengers provided to him, right?
Yes, and the other way around.
Well, what information did he provide? Do we know?
He provided multiple times. He sent an email containing the website for Mariner, and the website contained the terms and conditions.
So then his email also must have said, you need to go on the website and check mark a couple of these things to confirm that you're bound by these, right?
No,
so he didn't do that either.
No, he didn't.
So what did your client do to assure that the passengers who were not chartering the vessel knew that they were giving up certain rights and remedies that might otherwise be available to them?
Well, they posted the terms and conditions on the website, which was provided to them through the lead charterer more than once. And they, as passengers, potential desirous passengers on the trip, they had multiple opportunities to look at it, and they did.
So what did Mr. Paybara do to hold out the charterer as being his agent for whatever purposes your client thought he needed to be the agent for them?
Well, he has admitted in this case at page 216 that all of the private information that he gave to the lead charter was for the purpose of booking. And everyone from, there's a reasonableness element here. People know—
A reasonableness element to me would be that if your client wants to hold somebody bound to all the terms and conditions, including the waiver of certain constitutional rights, that your client would see to it that a document is signed or some confirmation is given that, yes, I know I'm giving these rights up. I mean, that sounds to me to be pretty reasonable, but I'm sure you'll explain to me why I'm wrong.
Well, there is more than one way to skin a cat, Your Honor, and that would have been one way to do it. The other way is to work through the lead charterer, and that's what was done here. And he gave them the information that they needed had they wanted to investigate what kind of boat it would be and what other information that Mariner made available to them, and they admitted that they didn't do it. Look at page 214 of the appendix. They were given the website multiple times, and they don't deny that. They admit that. And if they had opened,
I guess one might, Ms. Paul, one might, and I'm sure your opposing counsel has said and has indeed said that they were given that site to go look and check out the boat, because this was to be for the charterers, the lead charterer's 50th birthday party, and these folks were just passengers coming along for the ride. I think let me make sure I have a grasp on the record. The passengers, other than the lead charterer, none of them had any direct communication whatsoever with your client. Is that right?
That's right.
Okay. And so all of the information that you have is through the lead charterer. What representations did the lead charterer give to your client that would have shown them that the passengers were granting the lead charterer the authority to enter into this agreement, other than being a passenger? And the reason I'm asking that question that way is because I understand that the passengers gave their passport information, they gave their phone address, they gave all of the information that your company could have easily reached out to them to give them any information, but chose not to. So what information did the lead charterer give that he had the authority to enter into those terms for them?
He didn't specifically give them anything other than the website. And they were, this is where we get into the ratification element.
So how did, and your client only received those emails after the fact. So how would your client have relied on those emails?
No, I don't know what you mean after the fact, because those emails were sent before the trip.
I know, but your client would not have had access to that. So I'm asking you, what representations did your client receive to assume that the lead charterer was acting on behalf of the Parabays?
I think that they required the lead charterer to provide various points of personal information about all of the passengers, to identify them, to give their social security number, their birth date, their
passport. I don't remember a social security number. I went back through and looked at the request for admissions, paragraph 28. I don't remember social security number.
Passport number for sure. I'd have to double check on that. But in any event, the only way the lead charterer has that is to get it from the passengers.
And it would make sense to do that for someone concerned about passengers arriving into a foreign country and having all of the identifying information of their passengers on a boat. That doesn't necessarily equate to the fact that they're agreeing to all of the booking terms.
But they gave him, there's no question from what they did, the facts of what they did, that they gave him the responsibility to book the trip. And the law is that if there is something that is reasonably necessary and incidental to the booking, such as the contract here, that is within the scope of the agency relationship. But let me
and I guess, yeah, and you're referring to which is your best case on that point?
That
the bank.
Gosh, there are so many of these cases that talk about in our brief and elsewhere that if something's within the scope, just trying to find the best case for that. I don't know, I can't really answer that. off the top.
Let's assume that we agree that there are cases that support what would reasonably be within the scope. What makes an arbitration provision reasonably within the scope of any contract as a matter of just law that, oh yeah, of course it's reasonable to have an arbitration provision?
You don't look at the provision. It's reasonable to expect that there would be a contract for the charter of this boat. Even the lead charter said a passenger would be naive to think that you could rent a valuable boat like this or charter a valuable boat and that there would be no contract.
Well, and of course that would be naive if the person who was chartering said, I didn't know there would be a contract. I didn't know I was entering into a contract. But you have multiple people who were not chartering. They were going along to celebrate his birthday on this vessel that he chartered.
They paid for the privilege of going on the boat. They paid for it. So this is a transaction.
They paid your company, or they paid him the money and then he paid your client whatever way he chose to pay your client?
They gave him the money, but it was for Mariner. They gave him the responsibility of paying Mariner their fare. And that just solidifies the fact that he was acting as their agent. But let me move past this for a little bit to the issue of ratification. If there's any doubt about whether they had given him the apparent authority by the facts that occurred before the trip, they flew to Belize. They got on the boat. They participated in the cruise. They accepted the benefits of the contract. And the law is that you can't accept the benefits of a contract without the burdens. Now, the answer brief says, well, under Frankenmuth, you have to, a principal has to have full knowledge of what the agent did in order for there to be ratification. But as always in the law, there's an exception to that. And when the principal is willfully ignorant of the details, then that contract is ratified just as if the principal had given actual authority at the beginning. One of the best cases is a second supplemental authority that I filed just a couple of days ago. It's called Domino from the 4th DCA. And it's not an arbitration case, but it's a ratification case where somebody was emailed certain information and they said they were too busy to read it. They didn't read it. And the 4th DCA said, no, a person, I'm quoting, a person has no right to shut his eyes or ears to avoid information and then say that he has no notice.
But Ms. Pohl, the difference in that case is the actual contracts were emailed to the principal. In your case, you're telling us what was emailed to the principal was information about a website.
No, it was the website itself which contained the actual contract.
So what you're saying is that the principal had, if we agree he's a principal, that the principal had the obligation to navigate the entire website to look for anything that might contractually bind him.
I think you're making it sound more difficult.
Well, I am, because the case that you're telling me is now so controlling has very specific language that says the contract itself was emailed. The contract was emailed. Your client didn't email the contract. As far as we know, the charterer didn't email a contract. He emailed information regarding a website. And as Judge Smith pointed out, that information is very consistent with the idea of take a look at the boat we're going to go on to, take a look at the itinerary we're going to go on to, not take a look at the contract because you are agreeing to certain terms that you might or might not want to agree to.
There were any number of questions from all of the passengers, the 13 or so other passengers on these boats. And the lead charterer said, here, look at the website. And the minute they opened the website, they didn't have to search around. They would.
Paul, let me ask the question this way. What did the lead charter receive, either a link or a copy of the contract. So a link to the actual contract that he signed, or a copy of the contract in an email from your company.
I'm not sure I understand the difference.
Well, one would be, here's a link to the contract, and then he can click on it and then it pulls up the link, okay? Like if he had a booking and a password and created and registered as a user or an account, okay, so that would be one way. Or did your company give him a copy of the contract in an email, like a PDF? So
There's no evidence in the record that he received a specific.
okay, and so and I guess it follows that, you know, by him just sending a website link for someone to navigate through and figure out what the purpose of that was, that it's not even specific to any booking terms. I mean, your client didn't even, it doesn't even sound like in the record was built up that your client provided him a copy of the executed contract so that it would have been easy for them to see a copy of the contract.
I do know that what the record shows is that they received on multiple occasions a link to the website that would have shown them the terms and conditions of chartering a boat through Mariner.
And how many clicks would they have had to click to get to the actual terms?
I'm not sure that how many clicks.
Did it give directions, or it just gave a big?
I think that the record says that when you open it, you'll see a thing that says terms and conditions. At page 210 of the appendix, Peter Cochran's affidavit, who's the vice president of operations, and he said, at all relevant times, the booking terms and conditions containing the relevant arbitration provision was available for public viewing on Mariner's website. I don't believe that the record is any more specific than that. But
You are almost at 17.
okay, then I want to focus on ratification. They went on the trip. They accepted the benefits of the booking that they admittedly authorized the lead charterer to book on their behalf. And they were, in the language of the cases, willfully ignorant of any further details about this trip. And they were sophisticated travelers. It's not like they had never gone on a trip like this before. They've met, or I should say, we've met our burden to show that they ratified the contract, whether or not that they even knew it existed. Because
When you say trips like this before, is there any evidence that they have gone on other chartered vessels and had the opportunity to know they were bound by an arbitration agreement?
the record is not that specific.
So they're sophisticated travelers in some unknown way, is what you're saying?
Yes,
Okay.
yes. This meets the requirements for willful ignorance, which has been part of the law. One of the cases cited in Frankenmuth is from 1898, which goes beyond where I usually like to find my authorities, but it's still being cited by the Florida Supreme Court more recently, and it is the law. You cannot accept the benefits of a contract without accepting the burdens. And I want to refer you to one excellent case, which is in the cruise context, and that's Calixterio. It's a Southern District of Florida case, and it's a ticket case. I understand that the appellee tries to distinguish it that way, but it really cites a lot of cases in the travel industry which say that the fact that someone else is holding the ticket and holding the information doesn't matter. Anybody who goes on the trip is bound by the terms of that ticket. And that's what this case is. They went on the trip, they're bound on the terms of the contract that the agent that they authorized to book the trip signed on their behalf. So we ask that the court reverse, and let me just add that the trial court made no findings. So the facts are what the facts are. This is a question in the nature of a question of law. And this court can find that the trial court was wrong and reverse and send this case to arbitration.
Stop the clock. We will hear from the appellee, Mr. Mitchell.
Thank you, Your Honor. May it please the court, I'm Wayne Mitchell. I'm counsel for the appellee, Joshan Paybera. There's two kind of overall issues here. In order to compel arbitration, the parties must have agreed to arbitrate, and Mariner has the burden of proof on this issue. Now, I think Mariner's trying to pull a little bit of sleight of hand. The contract at issue here is a vessel charter agreement. It is not a trip or a booking or as in a cruise ship case where each passenger has a ticket. This was a charter contract where one person can charter the vessel and then allow other people to come on the vessel. And so there was no reason, while it's true that as Mr. Walker and the Paybearers agreed, that it's reasonable to assume that Mr. Walker would have to sign a contract to charter the vessel. There's no reason why the Paybearers would have been aware that the charter contract also included them as parties without someone bringing that to their attention. So, you know, the Paybearers and Mr. Walker actually one thing that you asked, and I want to touch on this briefly, which is what representations were made by Mr. Walker to Mariner, because obviously the Paybearers had no contact with Mariner.
Well, is that the proper focus? Because as you look at UTAP, the case that they cited written by Judge LaRose, the focus is on the appearances created by the principal. The principal will be your client. And so what appearances arguably did your client do to create the apparent authority in Mr. Walker to waive your client's rights?
And my answer to that would be nothing at all, because all of the information Mariner had came through Mr. Walker, and the cases are pretty
Would not
clear.
that be the burden of the appellant to show the apparent agency under
Yes.
the very case they cited?
Yes. But one thing I wanted to point out is the only evidence that they received from Mr. Walker that he had authority to sign a contract on behalf of the passengers was an ambiguous statement in the boilerplate of the contract. And that statement was the person making the booking, the lead charterer, and he was designated unilaterally the lead charterer by Mariner in the contract. There's no evidence that the passengers had said, oh, you're going to be the lead charterer. Must be 18 years old or over and possess the legal capacity and authority to make the booking and accepts these booking conditions on behalf of everyone in their party. Now, again, this is buried in the boilerplate and a lot of people don't even look at that, but a non-lawyer looking at that is, I think they may not realize that, oh, in signing this, I'm telling Mariner that I have authority from all the passengers to commit them to this contract. I don't think many non-lawyers would recognize that that's possibly what that means. And that is the entire branch that Mariner is holding to say, we were told that Mr. Walker had authority to sign on behalf of the passengers. So I think it's apparent authority. One of the things that's striking in this case is apparent authority has three elements, and it's repeatedly been followed in Florida law. And in all of the briefing by Mariner, below and before this court, they've never laid out what the three elements are and how they met those elements. And the elements are a representation by the alleged principal, a reliance on that representation by a third party, and a change in position by the third party and reliance on the representation. And it's our position Mariner can't establish any of these elements because there were no representations by the paybearers directly to Mariner. The case law says that Mariner can't rely on representations by Mr. Walker regarding the nature or scope of his authority from the alleged principal. They can only rely on representations by the principal. And, you know, they've cited a number of cases, but what they've done basically is taken statements out of those cases out of context and then included them. For example, in Jadon, paying money and silence can be representation. But in Jadon, the silence was a situation where the principal and the alleged agent were present with the third party, and the alleged agent made statements to the third party, and the alleged principal said nothing. And there the court said, well, the alleged principal's silence there is an indication that they're accepting what.
Mr. Mitchell, why can we not consider the information that was the personal information, passport, address, phone numbers, etc.? Why can we not consider that information as representations on behalf of the principals through Mr. Walker?
I think there's two issues there. And the first is that whether they were a party in the contract or not, it was reasonable for them to provide that information so they could be a passenger on the ship. And so the fact that they provided the information to Mr. Walker isn't an indication that they've given Mr. Walker authority to sign for them. It's only an indication that Mr. Walker said, I need to have this information if you want to go on the trip. And they said, oh, okay. And the second is that, again, Mariner doesn't know for certain where Mr. Walker got that information. And theoretically, if you had a situation where the alleged agent was trying to claim he had authority when he didn't, he could have come up with that information in some other way. He'd had prior trips with the paybearers. Maybe he had that information, we'd received that information in the past and they didn't even need to get it from him. So I think the case law is pretty clear that it has to be a representation directly between the principal and the third party. And they can't just rely on communications from the intermediary. If that answers your question. So, you know, they can't show representations. And they also can't show they relied on these representations because they weren't aware of the representations because they weren't made directly to them. All they were aware of was what Mr. Walker had told them, which are not proper representations to rely on. One other thing I'd point out.
Mr. Mitchell, opposing counsel has referred us and argued in the brief the Calixtero case, which involved, I think, if I remember, a Carnival cruise ship and ticketing that's issued for individual passengers. I'm not sure if you're prepared to address this based on the record. I'm not sure if the record tells us this. Were individual tickets issued for each of the passengers?
No. In fact, and that's the difference between Calixtero and all the other cruise ship cases in this case. In all those cruise ship cases, there was a specific fare paid on behalf of the passenger, whether it was paid by the passenger or someone else. And then a ticket was issued, and that ticket had the terms and conditions. And in the cruise ship context, the courts have said, as long as the information on the ticket reasonably communicates this information, if the passenger who knows they have to have a ticket get on the vessel allows someone else to handle the ticket, their ticket for them, well, we're still going to say that they were reasonably communicated. Another difference I would point out is that the issue in Calixtero was a 1 year statute of limitations. And the court pointed out that after the cruise, when the passenger was made aware of this ticket, they were also made aware of the 1 year statute and the forum selection clause, and they chose to violate that. Whereas here, you know, by the time that the Payberas were aware of the contract, there was nothing they could do about the arbitration provision. And one of the things that well, I think I've already talked about that. One of the things I'd like to point out is all of the actions that the Payberas took that Mariner points to would have been totally consistent with the Payberas' understanding of the situation, which was that Mr. Walker had chartered the vessel. They had agreed to reimburse essentially Mr. Walker for a portion of the charter fee in order for Mr. Walker to allow them to go on the vessel. And part of that proceeding was that the company that owned the vessel and was chartering it to Mr. Walker wanted the information from all of the passengers since they were coming in from overseas. And it's really no difference, for example, in a car rental case, the car company, I go in to rent a car, the car rental company will say, is anybody else going to drive this car? If so, we need their driver's license and things like that. That doesn't mean that the person who, my friend who's going to go in the car with me, and maybe he's going to split the cost and maybe he's not. That doesn't mean that he's renting the car. I'm renting the car, and he's just somebody who's going along based on a verbal agreement with me.
And there might even be a distinction there if the person is going to be added as a potential driver of the vehicle. A different standard might apply as opposed to somebody is going to take a trip with you from Miami to Tallahassee. You're going to rent the car, but they're going to split the costs, but you're going to be the only driver. I mean, it seems to me that's more analogous to our case as opposed to someone being listed as a co-driver on the form.
But I'm just saying that it's not unreasonable for someone who does not believe they're a party to the charter contract to be asked to provide personal information to the vessel owner since they're coming in from overseas, and they want to make sure people are, they're not bringing in people who aren't old enough or, illegal immigrants or something. And so providing that information is not inconsistent with their understanding that they're just a passenger, they're not a party to the contract. And that's also a reason why they wouldn't necessarily look at the terms and conditions on the website. They're sent the website. Hey, if you want to look at the boat, do it. If you don't. The record's silent as to whether they actually did look at the boat or not. But there'd be no reason if they didn't realize that they were a party on the contract for them to look at the terms and conditions, because again, they're not a party, and so it doesn't matter. There's a couple of cases that cited by Mariner that as apparent authority cases, but they're really implied actual authority cases. And I think those are DeMille v. Citibank and Dye v. Tamco. And in both of those cases, DeMille involved middlemen essentially establishing an account on behalf of the principal. And there was no question that the principal had authorized them to set up an account. And the issue was whether they also had authority to sign the paperwork that included the arbitration provision. And, it wasn't their account, it was the principal's account. And the court said, yeah, under these circumstances where these guys, you've given them the authority to set up account for you, they also have authority to sign the arbitration provision. And Dye v. Tamco, I think, is similar in that you've got property owners who hired a roofer to put on a roof. They had to obtain the roofing material. The roofing manufacturer put terms and conditions on the packaging, and the plaintiff sued. Roofing company said, wait a minute, there's an arbitration provision. Again, it's very clear that the roofer was an agent for buying roofing material, putting it on the plaintiff's houses. And as part of that process, the court said, well, we're going to basically imply that as part of that authority, they had authority to take in the roofing material, open it up and put it on the house, and we're going to call them an agent for purposes of what's on the packaging material. And here, that might be more like the cruise ship case where there's an actual ticket with terms and conditions. Here, the paybearers had no intention of authorizing Mr. Walker to sign a contract on their behalf. And Mr. Walker didn't intend to sign a contract on their behalf. And he didn't read the contract carefully like a lot of people do. And he didn't realize that he'd signed a contract on their behalf. So he never told them of that fact. Now, another issue of ratification. The case law in Frankenmuth is very clear. You have to have actual knowledge of the contract. Should have known is not enough. And it's not actual knowledge of just part of it. It's actual knowledge of the terms of the deal, basically. And here, they didn't have knowledge that they were even a party to the contract. And the contract was not just the arbitration provision. There are a number of other important provisions in there. There's a limitation of damages in the contract. There's time limitations for filing suit, and as well as the arbitration provision. And the paybearers were totally ignorant of that because they didn't know they were a party to the contract. So they couldn't have actual knowledge. Now, I'd actually like to thank Mariner for putting in the Domino case, because I think that shows what willful blindness really is. And there, as the court pointed out, the alleged principal had been sent 6 copies of the contract directly from the third party, chose not to open them. The alleged principal's manager, who was an agent of the alleged principal, did open the email additionally. And there, the court said that's willful ignorance. You had all the information and you didn't act on it. Here, the paybearers didn't have the basic information that they were a party to the contract. They had no reason to know that when Mr. Walker signed a contract to charter the vessel, he was also signing a contract that committed them to a contract, an obligation with Mariner, between the paybearers and Mariner. And so, I don't think they can even show that the Mariner should have known that they were a party to the contract. And if that's willful ignorance, then the actual knowledge, not subjective knowledge provision in Frankenmuth would become swallowed up, because everything would be willful ignorance. Does the court have any other questions for me?
Don't see any.
Well,
I'll
if
second
not,
Judge Silberman.
I will conclude.
Okay, thank you, counsel.
I have 3 minutes.
No, counsel, I have notified you. You were at almost 17 and you kept going to 19 and a half.
Okay,
You
then I'm
have
just
30 seconds.
Okay, 30 seconds, I'll say this case may boil down, based on this argument, to willful ignorance. Just like in Domino, he was sent an email multiple times. He admits it, that if he had opened it, would have shown the terms and conditions, and he just didn't do it. Not reading a contract is no defense. Not opening that email is no defense. The law here of ratification suggests that this case should be one where a non-signatory is bound by a contract. We think this court should reverse.
Excellent. Right on time. Fantastic. Thank you. Thank you both. Well presented. Appreciate it. Please, everyone, stay well. We hope to see you sometime in the future in a real courtroom.
Thank you, Your Honor.
Thank you.
We will move on to the next matter, which is Halprin and Castellano.